Morning, everybody. Welcome to the First District Court of Appeals. Today we have two cases that will be argued. The first case is the City of Cincinnati versus Fourth National Realty, case number C220209. Would the attorneys please state your appearance and your readiness to proceed?
Eric Holzapfel on behalf of the appellant, Fourth National Realty.
Good morning.
Arian Haynes and Mark Manning for the City of Cincinnati, ready to proceed.
Good morning. And the second case to be argued today is State of Ohio versus Mitchell, case number C210623.
Good morning, Michelle Barrigazzi on behalf of Luma Mitchell, and we're ready to proceed.
Good morning.
Good morning, Your Honors. Pete Slaughter with the state. I'm ready to proceed as well. Thank you.
All right, good morning. So Mr. Holzapfel, if you'd like to approach the podium, and how much time would you like for rebuttal?
Ideally 5 minutes.
Okay.
See how I do here.
Okay. I'll be keeping your time. When you have about a minute left, the yellow light will come on, and when you're finished with your first 10, the red light will come on.
Thank you.
Whenever you're ready.
Okay. Again, for the record, I'm Eric Holzapfel. I represent the appellant, Fourth National Realty. This case involves two sections of the Cincinnati Code, 141139A and 142717, both of which prohibit my client's John Morrell sign being placed on its building. The fourth sign, I'll call it the Fourth National sign, John Morrell sign, is actually both an outdoor advertising sign and an off-site sign as defined in the Cincinnati Code. Prior to 2020, the city treated them the same. An outdoor advertising sign was the same as an off-site sign. That changed in November of 2020. An outdoor advertising sign is a sign where rent's charged. An off-site sign is a sign that promotes a product that's not sold on the premises. Okay, everybody knows that. What this case is not about is the size of the sign, quantity of signs in the city, construction of signs, whether they flash or make noise. It's not about any of those because the city can regulate those. This case is about the content and location of signs. Both signs regulate speech. Actually, they prohibit my client's speech. And these are guaranteed by the Ohio Constitution, Article 1, Section 11, and the First Amendment to the United States Constitution. So even under the intermediate scrutiny standard set forth in the Central Hudson case, the burden is on the city to prove that their prohibition of my client's signage directly and materially advances its substantial governmental interests.
So you agree that intermediate scrutiny is the appropriate level here, right?
Yeah, we're going with the intermediate scrutiny. Yes, we'll go with intermediate scrutiny on this situation. The Ohio Supreme Court has applied that in the Norton case, so we're going to go with intermediate scrutiny.
Let me ask you, Mr. Holzapfel, I know the city relies on aesthetics and pedestrian safety in cases cited. Other courts have found that sufficient. How are we to find that insufficient here?
It's insufficient here because there's two ordinances involved. Number one, the Norton case, the Ohio Supreme Court has said that you cannot differentiate between off-site and on-site. You don't even get to really substantial government interest because under the Norton case, it's content-based. If you discriminate.
Let me stop you there.
Okay.
At least my reading of Norton was that there was no basis provided by Arlington Heights. There was no aesthetics, no pedestrian safety. They just said, we don't want this sign on these properties. So there was no basis, and at least my reading of the Norton case indicated that was a reason.
Sorry, I didn't mean it.
No, you're good.
The court found that they had not established a substantial interest in government, in the traffic safety or aesthetics. In this case is different, okay? The reason it's different is when they changed the law in 2020 to outlaw or prohibit outdoor advertising signs under 141139, they basically ignored the governmental interest that they've been alleging for 7 years, because under 141139A, this sign, this John Morrell sign, is allowed. Okay, so if they allow it under 141139A, they can't go over to 142717 and say, well, wait a minute, it's a traffic safety issue, it's a aesthetics issue. How can you argue that under any circumstances if one of their ordinances that they just amended specifically allows this sign, as long as they don't charge rent for it? And I would ask the court, it's the same sign. Whether somebody charges rent to put the sign there or doesn't change the content of the sign. So
Counselor, how would you distinguish this from City of Austin versus Reagan National? The Supreme Court case.
Oh, City of Austin.
Yes.
I wouldn't distinguish it. The Supreme Court of the United States has determined that an off-site, on-site distinction is legitimate, is constitutional. But the Ohio Supreme Court, which governs the interpretation of the Ohio Constitution, has disagreed with that. And way back in 1982, that law is still good. That Norton case is still controlling law.
So are you saying that City of Austin didn't change the law?
I'm saying it didn't change the law in the state of Ohio. If we were in federal court and it was strictly a First Amendment issue, I think the City of Austin case controls. But we're not in federal court, and I'm arguing that along with, as found by the Norton court, that what happened here is that it violates Article 1, Section 11 of the Ohio Constitution. And just to hit home the point I was making with Judge Winkler, because of the change, they've changed the law 2 or 3 times since we've started this thing, but I think the change in 141139A is a killer for the city, because it specifically allows our sign as long as we don't charge rent for it.
So if they had not done that amendment, would you agree that the traffic and safety, or the aesthetics and the traffic safety, would be reasonable grounds to prohibit the signs?
No, I wouldn't. And the reason I wouldn't is, if you walk around town, take judicial notice, if you will. If you walk around town, just driving in today, right here in the building to the west of this courthouse, of the main courthouse, is a digital sign advertising a gambling operation, FanDuel. It's a flashing, every 8 seconds it flashes a different commercial message. This is what the city has allowed, okay? Also, the city has put kiosks around the city. If you look at those, they're about this level, so if you're driving by, it distracts you, if you will. Commercial advertising, MGM, more gambling advertising. This is what the city allows.
So are they just making special exceptions for those?
Well, you know, when does the exception obliterate the rule? I mean, they're claiming that they have a substantial interest in traffic safety, then why are they putting digital kiosks on the sidewalks where cars are traveling by? And notice them, why are they on the Coliseum? They have plastic surgery advertisements. There's no plastic surgery being conducted at the Coliseum. They have Dinsmore, my old law firm, has a sign on the Reds Hall of Fame. Those are all off-site outdoor advertising signs, and the city has allowed all of it.
So you're saying they're applying these ordinances
Selectively.
select-
I say they don't, Your Honor, I'm saying they don't have credibility saying that they have a substantial interest in aesthetics, because of the signage that they are intentionally allowing to be placed all over the city. Look at the stadiums. Toyota's got a truck, okay, popping out of the top of the stadium. I'm saying that if you look at all that, I'm not sure they even satisfy the second prong or the third prong of Central Hudson. But again, the killer here is, if they're going to say that my client's sign is a traffic safety or aesthetic issue, then 141139A, which specifically allows that sign, completely destroys their claim that this sign is an aesthetic or traffic safety issue. I might also say that we've submitted some affidavits that are in the record showing a lot of this signage, okay? And I've got an expert report that's in there where it did an extensive study concluding that the city really can't claim a substantial interest in aesthetics if the exceptions obliterate the rule.
What about safety?
Same thing.
The distraction for drivers when pedestrians are trying to cross the street.
I don't think they can claim that if they're going to put up all these signs themselves. How can they say that my client's sign on the wall on 3rd Street is a traffic safety issue when they're putting kiosks with flashing signs on the sidewalk right next to the street?
So your issue is really what you're claiming is selective enforcement by the city.
Selective enforcement by the city, but I don't know that we even need to get there because, again, the amendment of 141139 specifically allows a sign, my client's sign, on its building as long as they don't charge rent for it. And I would suggest to this court that whether or not we charge rent for this John Morrell sign isn't going to change the sign. It's invisible to the public. So it also puts 141139A in direct conflict with 142717. 142717 says it's an off-site sign, promotes a product not sold on the premises. Okay, not allowed under that one. You have to consider Norton. Here comes along 141139A and says, that sign's okay, as long as you don't charge for it. What? They're in direct conflict. One says the sign's okay, one says it's not. But I think
Just to let you know, you are at 11 minutes if you wanted to reserve.
Okay, I'll just say one, I'll just say, but the overriding issue here is the city's own acknowledgement that this really is not a traffic safety or aesthetic issue because it's allowed under one section, arguably disallowed on another. And I'll say whatever 3 minutes I had. Thank
About
you.
3.5.
Good morning. And may it please the court.
Is the city selectively enforcing these ordinances?
No, Your Honor, the city is not. First of all, that matter's been litigated. It's been finally decided by this court, and it's not before the court today. So no, the city is not selectively enforcing. I'd also like to address the contention that the recent change in the definition of outdoor advertising sign would allow for this sign to be posted downtown. It would not, because any sign that would be posted downtown would have to comply with both 141139 and 142717. And because it wouldn't comply with 142717, it's not permitted. Otherwise, there would be no reason to be here today because the sign would be permitted in this case would be moot. So after 8 years of litigation, we're really down to one question is, are these provisions that are in controversy constitutional? And the trial court below applied the correct standard and found that the city had presented evidence that left no question of material fact whether or not it was entitled to judgment. Judge Hathaway gave judgment in favor of the city. The court reviews that decision here de novo, and thankfully, despite the disagreements between the city and the appellant, there is agreement that the Central Hudson standard, the intermediate scrutiny standard, is the standard the court should apply. And just like the court below, this court should apply that forward part test to reach the conclusion that the city's sign regulations are constitutional. I would like to address the question of Ohio constitutional claims versus United States constitutional claims. the appellant here, really, the thrust of their arguments prior to this immediate appeal have been claims under the First Amendment of the U.S. Constitution. After the City of Austin case was released by the Supreme Court, the focus became the Ohio Constitution. I don't think that really matters much for the purposes of this court's analysis, because Ohio courts, and the Supreme Court of Ohio in particular, have always applied First Amendment jurisprudence to determine the meaning of Ohio's own free speech clause. So those, whether it's Ohio Constitution or U.S. constitutional law, they're really one and the same. And so this court should apply any First Amendment jurisprudence in arriving at its analysis of the Ohio Constitution. And I'll add that other than contending that there is a difference under the Ohio Constitution, the appellant has done nothing to actually develop that argument or to establish that Ohio does look at its own free speech clause in a different way than the United States Supreme Court looks at the First Amendment.
If this court were to look at Ohio's Constitution, and if we were to look at Norton as controlling law, could you explain how this case is different than that?
Well, Your Honor, I would, yes, I understand your question. So Norton tracks Metro Media. And in each of those cases, the United States Supreme Court in Metro Media and the Ohio Supreme Court in Norton analyzed an ordinance that distinguished between on-site signs and off-site signs, looking at them in two different ways. One was how they impacted non-commercial speech. Mm-hmm. And the court in both of those cases found that to the extent those ordinances impacted non-commercial speech, they should be subject to strict scrutiny, and therefore almost
because it was content-based, truly content-based.
It was because it was because the effect of the ordinance was to prefer commercial speech on site over all other types of speech. Okay. And while it wasn't expressly a content-based provision, because of the effect of favoring a certain kind of speech, the court found that it therefore disadvantaged non-commercial speech in that case. And so that is not the case before the court. That court dealt with that issue in the second appeal and found that the city, through prior revisions to its sign regulations, had made it very clear that these are just commercial sign regulations. So the second half of those cases dealt with the impact of those ordinances on on-site commercial signs versus off-site commercial signs. And in that case, both those courts applied the Central Hudson test, the four-part test. The main difference here is the city here has provided an ample record to support the findings that justify a finding of constitutionality under the Central Hudson test, whereas in the Norton case, the Supreme Court said that the city of Arlington Heights or the village of Arlington Heights had provided no such record.
So the city provided expert testimony, I think, right, from two different experts?
Yes, Your Honor. We provided testimony from zoning experts and from traffic experts, and those experts confirmed that providing for aesthetics and traffic safety are legitimate goals of the city. That's also reflected in the city's ordinances. The city council has called those out as goals of the city. And those experts also addressed, one, how these ordinances advance the goals of aesthetics and traffic safety. And it's quite simple. It advances them by not allowing certain types of signage. And it went to the level of detail of looking at, hey, we have certain areas in the city where we have higher incidence of traffic conflicts with pedestrians and vehicles. We have certain areas of our cities that are recognized for having greater architecture, or places where people reside and have residences where those concerns are heightened as compared with, say, maybe like the Mill Creek Valley, where some of these signs would be permitted. So not only has the ordinance addressed the concern of aesthetics and traffic safety, but it has done so in the areas where those issues are of greatest concern, and it has nonetheless permitted the signs in the areas where they're not. Now, we've heard from the appellant that they're trying to make what's really an under-inclusive argument here, that the city should have to ban all the signs in order to prove that it really has legitimate goals here. But this argument has been addressed before. It was addressed head-on by the Supreme Court, in the United States Supreme Court in the Metro Media case. And in that case, the court made it very plain that cities can determine that different levels and types of signs may be permitted. For instance, the city putting up traffic signs and traffic control signs obviously are some of the highest level of concern, addresses some of the highest levels of concerns that we have regarding traffic safety. Also, the need for businesses to be able to identify themselves and provide wayfinding for people. The city can decide that allowing those on-site commercial signs, but not some of the off-site commercial signs, is appropriate. And in some areas, the municipal interest can give way to some of what the city council may choose as these greater interests. But that's within the judgment of the legislature to decide, and the Supreme Court has confirmed that. So I think I've addressed all of my points. If there are any questions that I can answer for the court, I'm happy to do so and make myself available. Otherwise, I would cede the remainder of my time.
Looks like not.
All right.
Thank you for your argument.
Thank you.
Mr. Holzapfel, you have 3.5 minutes.
Okay, so a couple points that I'll be addressed here. They're experts. They're 3 city employees, okay? And remember, their argument is that this John Morrell sign is a distraction, and it's only because it's an off-site sign. If John Morrell were selling hot dogs in that building, they're saying that sign's not a distraction.
Well, they're trying to allow businesses to identify themselves, right?
But a sign's a sign, Your Honor. It's either a distraction or it's not. And if it's a distraction because it's an on-site, it's a distraction both ways. But here's what one of their experts said, okay? Mr. Letchlek, I think. He said it cannot be determined exactly how many of the estimated, he's talking about fatalities, traffic safety. It cannot be determined exactly how many of the estimated fatalities are specifically related to distraction from an outside person, an outside object, or an on-site event. This is their expert. He is supporting our position, okay? And there are other experts also, in essence, I think, if you look at those reports. But we also had an expert, and Kathy, can't think of Kathy's last name right now, but we had an expert, detailed report. The court might consider whether this creates a factual issue. We have experts on both sides opining, in some instances differently. But
So did your expert counter the safety and aesthetics?
Yes.
Okay, how so?
It was like a 40-page opinion, complete with references and pictures, and it's worth reading. So maybe there's a factual issue. I think if you look at their experts and our expert, I think they're all agreeing that an on-site, off-site sign, they're both distractions, and one of them isn't more of a distraction than the other, which 1411 pretty much acknowledges, because it says if you charge money for it, it's a violation of 141139A. But if you don't charge, it's okay. And they say, well, then they get caught up in 1427:17. But I would suggest that doesn't save them, because they've acknowledged by 1139 that there's no difference. They're both, all signs are distractions. You can't tell me that whether or not they're selling hot dogs on that building or not makes that sign more of a less aesthetic, more aesthetic, more or less a traffic safety. Mr. Haynes likes to talk about the Norton case and the commercial, non-commercial, but the Norton case very clearly said that if you differentiate between on-site and off-site, it is content-based and a violation of Article 1, Section 11. Very clearly. The City of Austin case only addresses on-site, off-site. It doesn't address the issue of 141139A, where the city is speaking out of both sides of its mouth. And I don't buy the argument that says, well, we can cover it. One covers the other. No, one disagrees with the other. And I don't think that supports their position. The one thing we didn't...
You actually are at your time.
Okay, the amendment issue, we've argued that in our brief. So I thank you for your time.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Okay. Our next case is State of Ohio versus Mitchell. Good morning.
Good morning, Your Honors.
How much time would you like for rebuttal?
I'd like to reserve 3 minutes.
3? All right. Whenever you're ready.
Good morning. May it please the Court. Michelle Berry Godsey on behalf of Ramon Mitchell. Your Honors, this is a clear-cut, straightforward situation about an extreme delay of 647 days to resolve a low-level case, a fifth-degree felony, where all of the state's evidence was known the day of the arrest, which occurred on January 12th, 2020. This case was not resolved until almost 22 months later, in late October of 2021. Now, according to Ohio Statute 2945.71, the state had 270 days to resolve this case. If the case had been resolved within that time frame, the case would have been resolved by September 12th of 2020. By the time that date was reached, the state had not even responded to the defendant's discovery. So the speedy trial clock had expired in this case before the discovery was even given to the defense. But again, it's a unexplainable, inexcusable situation because all of the state's evidence was known on the day of Mr. Mitchell's arrest.
Doesn't the fact that he pled guilty kind of get rid of your argument?
Well, no, Your Honor, for a couple reasons. This is a different assignment of error regarding ineffective assistance of counsel. There are cases directly on point, Matterly, Haverly, and Gray, or Matland, Haverly, and Gray, which address if there's a guilty plea entered after the speedy trial clock has already been violated, that's ineffective assistance of counsel if there's reason to believe that there was a speedy trial argument to begin with. And here, there is, according to the Ohio Supreme Court, State v. Butcher, once the 270-day clock is passed, once that threshold has passed, the burden shifts to the state to prove that the clock was stopped for reasonable causes. In this situation, if you look at all the different delays that occurred at different times, again, there's the 9 months attributed to the state not responding to discovery, but where the case really went off the rails was from March 2021 to October 2021, where the judge recusals started happening. And I'm going to get back to answering your question, but the reason why his guilty plea doesn't take away our argument is he was repeatedly insisting that his speedy trial right was violated. He was asserting this
By himself. I mean, so he's represented by counsel, but then he's filing motions on his own, right?
Correct. But this doesn't, it's not like he wanted to do this. He was backed into a corner and started having to self-advocate because no one was presenting his interests. As he ultimately stated in one of his filings, his counsel was not asserting that right. His counsel was signing time waivers behind his back without him knowing. As you'll notice, there's more than 20 continuances filed in the case. They all have a line for defendant's signature, and none of them have his signature. But he ultimately explains on the record that he never once knew that this was happening, and if he had, he would have said, no, I'm not allowing these time waivers. That was
They're allowed though, right? I mean, under Ohio law, defense counsel can sign time waivers without their client being brought in or having to sign them. I mean, they can sign on behalf of their client.
Correct, if the client agrees to that. So it's assuming a proper attorney-client relationship. If the attorney is doing these things without the client's knowledge or doing them without the client's permission, when the client is insisting that they want this case resolved one way or the other, and the attorney is going forth and doing this regardless, that's problematic because ultimately it's the defendant's constitutional right to a speedy trial that's then being violated, and that's their right to assert that. That's one of their constitutional rights.
So are you saying, so basically, in a normal case, if a lawyer just waives time for their client, comes in, waives time, the client doesn't say anything, that's fine. Even, I mean, maybe you might have a post-conviction thing later that the client was saying something, but if the client starts pro se filing things in front of the court saying, wait a second, my lawyer's waiving time, I don't agree, are you saying then that the court needs to kind of take action at that point?
I'm definitely saying that's problematic. And that's exactly what didn't happen here. It appears that what happened was, I'll address the first judicial recusal, which I think was where the case really went off the rails. But several months later after that, about 6 months later in September, is where Ramon started his own pro se filings. And one of the key things that he kept raising was how long this case was taking to resolve. And he tried to address this in person with his second judge, Judge Allen, and was shot down. So then it goes to a third judge, and you can see in the record, even the day of his guilty plea, he's talking all about the speedy trial clock. And Judge Cross cuts him off and says, are you aware, sir? I know you're not an attorney, you're probably not aware. When you're filing things, every time you file something, that's stopping the clock. Well, the Supreme Court of Ohio addressed exactly that in State v. Long and said, if you're filing something regarding the speedy trial clock in and of itself, that doesn't stop the clock. And one of the main problems here was he was essentially screaming into a black hole. I want this case resolved one way or the other, be it a trial or be it a plea. And, maybe he would go to trial and lose, but that's his right to do that.
I thought he didn't want a trial, because I read that transcript as well, and Judge Cross said, okay, we'll set this for trial, and then he's like, no, I'll take the deal. I don't want a trial.
Well, you have to consider a couple things. First of all, the case was snowballed out of control by that point. Secondly, before that, the point in the transcript that you just said, he was, again, trying to assert a speedy trial right and just getting completely shot down, because it's as though there was a stereotype here that there's this guy causing problems, filing pro se motions, they're gibberish, I can hardly read them, and I'm just going to blow those off, and I'm just going to resolve this case. And it's great that she wanted to expedite it and get through it. That's what should have happened. But she was ignoring the content of what had happened. And there were major red flags that should have been waived here. 2 judicial recusals coming ultimately before a third judge, and a client who's very vocal and trying to advocate on his behalf. You've got to take a moment, despite that 47 days have elapsed, and see what's going on. You have to, as the professional and the one presiding over the case, cut to the heart of it and see what's going on, and at least acknowledge that, and look into it, investigate. It really doesn't take that long to do. Look at what's he trying to say in all these handwritten motions. Why were these judicial recusals happening? Why did all this time pass? Where did these delays occur? And that is what didn't happen here. No one took the time to see what was the merit of what he was attempting to raise. So ultimately, he did say, no, I don't want a trial. But one, he's backed into a corner at that point. 2, he's tried to no avail repeatedly, even in that moment, to raise the speedy trial issue. And again, it's ineffective assistance of counsel for his attorney to even allow that situation to happen when the clock has been violated. And third, his trust in the system and his lawyer at that point was deteriorated. That speaks more to the being backed into the corner feeling. And the other issue, and this kind of goes to the second assignment of error, is he ultimately didn't even know what he was pleading guilty to. First of all, the offense doesn't even exist. There is no first-degree misdemeanor possession of marijuana for 175 grams of marijuana, which is what he pled to. Doesn't exist under Ohio law. Secondly, he believed, because there had been a 4th-degree misdemeanor pending on the suspended docket, which actually should not have been under Ohio law, it should have been bound over with the felony, he believed it was that 4th-degree misdemeanor that he was pleading guilty to.
How is that evident from the transcript? Because in looking at the plea colloquy, the judge was very clear that this was a M1 marijuana possession. She said it several times, and he acknowledged it. Now, I understand that doesn't exist, and that's a whole other issue. But I think the first issue is the knowing and voluntariness of the plea, and did he understand he was pleading to an M1 versus an M4? And it seemed very clear that he was pleading to an M1.
I can't speak to exactly what was in his head, but I can convey what he's said to me and what is in the record. And yes, it does state that on the record clearly. The judge says M1 and the plea form says M1. True. But to speak to his frame of mind and what is in the record is that 4th-degree misdemeanor had been on the suspended docket. It's of the same name, possession of marijuana, and for the same amount of drugs, 175 grams of marijuana. He had pro se filings in that municipal case too, along with the felony case, where he's saying, I want to plead guilty to possession of marijuana. I am guilty of possessing 175 grams of marijuana. This is another repeated theme of his filings. And when you take that into account with the fact that he doesn't know that there's no communication happening between the municipal court and the felony court, this could have all been resolved if the correct procedure had been followed, Rule 5B, and those misdemeanors had been bound over with the felony. There would have been no confusion about what was happening. But in his mind,
whether there was confusion, because it just sounds to me, you're familiar with the Ohio case law. The state cited it in their brief that you can plead to, I guess, a fake crime or whatever to resolve a case, right? As long as it's knowing and voluntary.
Well, I can't say that's exactly correct. Part of that's correct. It's correct that you can plead to something if it's knowing and involuntary, and you acknowledge what the law is and what the facts are. Here, there was no amendments made to the facts. There was no, if you look at the record and what was stated on the record and what he was pleading to, it was again stated 175 grams of marijuana. Yes, they said M1, but they didn't make any amendments to the facts. They didn't say this is an attempt or you're agreeing to a higher amount. If there had been those acknowledgments and amendments made on the record and he had acknowledged those, then that would be a different story, but that's just not what happened here, and that's
Wasn't
the reason
this-
it's not voluntary.
Wasn't this invited error?
No, Your Honor, because first of all, one, there's an ineffective assistance of counsel issue going on. So you have to always keep that in mind, where his defense attorney is not stepping in on his behalf and correcting the situation. But to address the situation that Judge Krause also just raised too, the voluntariness and the knowing nature of this plea just was not there, simply because sure, he can plead to anything if there's an agreement with the parties, theoretically, but here, there was no amendment to the law or facts made on the record to make it voluntary. One of the things that's required under the U.S. and Ohio constitutions is an acknowledgement of the criminal defendant if they're waiving their constitutional trial rights of what the law is and the application of what facts to the law. And if he is being insistent that he only possessed 175 grams of marijuana, and he's insistent that there was no trafficking going on, and again, there was no
How
trial.
would they have amended it? I mean, you're saying that they had to amend the element of the amount of drug?
I'm saying if this is going to be a valid plea, he
Right.
has to acknowledge a correct, an actual violation of the law. In Ohio, this isn't a real violation of the law. There's an
I thought you just
attempt.
said that you can negotiate that.
Well, it still has to be proper under the law. If the defendant is going to give a truly constitutional, voluntary plea that's knowing and intelligent, they have to acknowledge what facts apply to the law. And here, like I said, he's insisting it's 175 grams of marijuana. I was not trafficking. All I did was possess this amount of drugs. There has to be some sort of acknowledgement that you're either saying you attempted to possess more or you were attempting to traffic. But if all they're going to say is you're pleading guilty to possessing 175 grams of marijuana, in his mind, and under Ohio law, that is a fourth-degree misdemeanor. There's no other way about it. That's just what Ohio law is. And he knew he was charged with that, and he had been saying repeatedly and on the record, I want to plead guilty to possessing 175 grams of marijuana. So when he was finally doing that, in his mind, that is what he was pleading guilty to. If he's pleading guilty to possessing 175 grams of marijuana, that is a fourth-degree misdemeanor to him, because that's all that was ever acknowledged on the record.
You are way over your time,
Yes.
but I won't even count your 3 minutes against you because we did ask you questions.
Okay.
So
Thank
You'll
you,
have 3
Rena.
minutes in rebuttal.
Thank you.
Good morning, Your Honors. May it please the court. I think the thread that runs through all of these cases is that we want the state and the defense bar to be able to meet in the middle, and we want these guilty pleas that arise from that to be final, and so we don't have to litigate the Barker v. Wingo factors and that sort of thing. Just a few points. I don't have a lot to add to what is in my brief. State versus King, a case from Ohio Supreme Court, indicates that an attorney can waive time with or without the client's consent. I think in a case where you have a defendant who's working at cross purposes with his counsel, there's at least an argument that the speedy trial time was waived, so it's not as clear-cut as it might seem, and I think that was the inducement for him to enter this plea, because he might not have won the speedy trial issue.
I guess like the issue though, I understand the case or the case law that says that the attorneys can waive without, I mean, you don't want to have to bring the defendant in every time and have him sign the speedy trial waiver. I mean, I get that, but what about situations like we have in this case where he is filing these things saying, wait a second, my attorney's filing these on my behalf. I don't agree with this.
Well, and I think that's something that the court was presented with, and it's something that went into the calculation of whether he should enter a guilty plea or not. You know, he's attempted to assert this right, and another thing to consider in this case is that he had extensive consultation with an experienced and skilled attorney before he entered this guilty plea, And we have to assume that during that time, the trial court gave time for him to consult and said, we'll come back in however much time, that the trial counsel considered all of those factors. I don't think there's any indication in here that the trial counsel did not do that. There was a thorough criminal rule 11 plea colloquy in which the defendant was specifically asked if the trial counsel had answered all of his questions. You know, the standard, are you satisfied with the performance of counsel? Yes. Are there any questions? No. I don't really think the trial court could have done much more to ensure that this was a knowing and voluntary plea. He got the benefit of the bargain here. I think that any error was invited, and I think that this is just the kind of case that demonstrates why guilty pleas have a certain special place in criminal jurisprudence, is because of the finality, and we want to encourage the ability to do this, and I don't think there's been any demonstration of injustice in this case.
In the state's position, and you do cite case law, not from our district, but from other districts, is that you can basically plead to a legal fiction in order to resolve a case.
I'm sorry. Yeah, sure. I mean, I think they want the state and the defense to be able to meet in the middle, and we don't want to go back later and to take a look at this, because it is a guilty plea. It's a waiver of essentially everything. In this case, I think if he had been given a sentence that wasn't commensurate with an M1 or an M4, that there would be an argument here. He was given 27 days of credit for time served, which was within the boundary of what he could have gotten for an M4 anyway. So I think I think it just demonstrates why we want the state and the defense counsel to be able to meet in the middle in these cases, and why why the plea should stand here, and why the court's judgment should be affirmed. Unless there are any further questions, I'm going to rest on my brief.
Thank you. Thank you for your argument. Ms. Berry, you have 3 minutes.
I think the ultimate bottom line here is that the case should have never even reached the guilty plea. We have a situation here where the evaluation that should be happening is the Barker v. Wingo factors, the length of delay, the reasons for the delay, the assertion of the speedy trial right, and the resulting prejudice. And we've talked about the length of delay. The causes of delay is really problematic. I know I only have a couple minutes to go over this. It's discussed extensively in the brief. But like I mentioned, the case really went off the rails beginning in March of 2021. And you look, there is more than 8 months that passed from that point to when the case was ultimately resolved by plea. The plea should not have happened, because in that time frame, there's not a single one of the professionals involved in the case, not the defense attorney, not the judge, not the state, who's properly acting on behalf to insist that this case get resolved. There was an apparent conflict between the first judge and the defense attorney that was on the case at that time in March of 2021. That was through no fault of Mr. Mitchell's. And if the judge needed to recuse for that reason, which ultimately she did in May, but he did not go before a judge from March until September, and then only briefly to get shot down by Judge Allen, and then not again until October. So in this time frame, March 21 to October of 21, the case, nothing happened on it. There was Ramon starting to file things on his behalf, screaming about his speedy trial clock being violated, wanting to plead guilty to the possession of marijuana, and just no one listening, not a single.
Just so I understand, though, you're arguing ineffective assistance of counsel because the lawyer counseled him to plead guilty rather than litigate the speedy trial issue?
I think that what should have happened here is, yes, the attorney should have spoken that to the judge, because that lends credibility to the issue, and that would have made the judge step back and say, look, I really need to look at what happened here. I really need to look at how did all these delays happen? How did all this time pass?
But that would be what you're asking us to do, is to say that the lawyer was ineffective basically for not litigating the speedy trial issue.
Yes, but I
Because
think.
the speedy trial issue, you're saying, would have been successful.
Correct. And I think on that day of the guilty plea, when again, he's trying to get into it with the judge again, and this had happened the previous month with Judge Allen too. And when the attorney doesn't speak up and start, the attorney is the one that knows the law. Now incidentally here, Mr. Mitchell also knew the law because he had to take the case into his own hands. But the attorney is the one charged with knowing the law and advocating on behalf of the defendant, and he was appointed counsel. And when that attorney is not stepping forth and presenting that issue to the court doesn't have as good of a reason to think that there's a credible issue there. That lends a huge amount of credibility. So what I'm saying is the case shouldn't have even gotten to that point to begin with. Judge Marsh should have listened to him. Judge Allen certainly should have listened to him, let cooler heads prevail and actually see what's happening here. But certainly the third judge should have listened. But what made it more problematic is that the defense attorney was not stepping up and also acknowledging it and saying, yes, this is real. If you look at what caused the delays, which is a Barker factor, how long the delays happened, the prejudice to him, how often he's been trying to present this to the courts and being ignored, all of those tip in his favor to a successful speedy trial motion. And when the defense attorney didn't present that to the judge didn't have as much of a reason to take that seriously or think it was meritorious or credible.
All right. Thank you.
Thank you.
Thank you both for your arguments. The case is submitted, and we will issue a timely decision. Have a good rest of your day.